Can you hear me in the jail? Can the jail hear me?
Yes, I can hear you.
Okay. On the record in the matter of the state of Michigan versus Trincerio Flowers 25-01439, appearance, please.
Good afternoon, Your Honor. George Anid, Assistant Public Defender, on behalf of Mr. Flowers for purposes of arraignment only.
You're Mr. Trincerio Malik Flowers? Are you Trincerio Malik Flowers?
Yes.
Okay. I have a felony complaint here that alleges that on or about January 19th, 2025 and January 26th, 2025, that you did allegedly, contrary to the law, commit the act in count 1 of motor vehicle unlawful driving away, and that on or about January 26th, 2025 at 3866 Wilson, Lansing, Michigan 48906, that you did in count 1 willfully and without authority take possession of and drive or take away or did assist in or was a party to such taking possession, driving, or taking away a motor vehicle, that being a 2004 Pontiac Grand Prix belonging to another, that being a Nicole Reva Farr, and that's contrary to Michigan Compiled Law 750.413. That's a felony, and the maximum penalty is 5 years, and the Secretary of State is to suspend their driver's license. Count 2 is domestic violence aggravated, alleging that on or about January 19th, 2025, at 3866 Wilson, Lansing, Michigan 48906, that you did assault a Nicole Reva Farr, an individual with whom you had a dating relationship without a weapon and did inflict serious or aggravated injury upon her, but without intending to commit murder or inflict great bodily harm less than murder. This is contrary to MCL 750.818A2. That's a misdemeanor with the maximum penalty being 1 year and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 3 is charged as domestic violence, alleging that on or about January 26, 2025 at Comfort and Willow, Lansing, Michigan 48906, that you did make an assault or assault and battery upon a Nicole Farr, an individual with whom you had a dating relationship. This is contrary to MCL 750.812, and that's a misdemeanor, 93 days and or $500 and fines may be imposed. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charges read and the maximum penalty imposed in each count, sir?
Yes.
You have the right to counsel. Mr. Annette is here to represent you for the purposes of your arraignment only. You have the right to have an attorney represent you at all of your court appearances, and the right to be represented by an attorney if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, not guilty, or stand mute. If you stand mute, this matter will go all the way through to a jury trial. You have the right in this matter to have a preliminary examination within 21 days of today's date. Today's date being the date that you're being arraigned. You have the right to have that exam within that timeline unless you waive the timeline or the court finds good cause to go beyond the 21 days. You are currently scheduled for a preliminary examination before Judge Tony Flores. It's going to be Thursday, May 29th at 9 a.m. You have a probable cause conference before Judge Flores on May 22nd at 9 a.m. You must appear in person for your preliminary examination. Did you get a notice to appear?
Yes.
You have the right at the time of your preliminary examination to require the prosecution establish sufficient probable cause that the felonies that was committed were actually committed, and that there's sufficient probable cause to charge you as the individual who committed those felonies. Do you have any questions about that?
No.
Okay. Again, you have the right to take this matter to trial, and you have the right to a jury trial. You are innocent until proven guilty, and you can require the prosecutor prove your guilt by continuing to trial and having them prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial, and it can't be used against you. You have the right to see, hear, and question any witness called to testify against you, and the right to subpoena witnesses that will testify on your behalf. Do you have any questions at this time?
No.
Is he requesting the public defender's office to represent him?
Yes, Your Honor.
Court's going to enter a plea of not guilty on your behalf. Are you currently employed?
Yes.
Where?
This place called New York Fried Chicken. It's a new chicken spot.
What's your home address?
3866 Wilson Avenue.
Is that where Ms. Farr lives?
Yes.
Okay. But where are you going to live during the pendency of this matter, because you can't live where she lives?
Oh, my mom's.
What address is that?
5330 Star Avenue.
Is that in Lansing?
Yes.
What's your phone number?
517-574-6288.
Are you currently on probation or on parole?
Yes.
Which one?
Probation.
Before which court?
St. John's, Lynn County.
Do you have any other court matters that are pending at this time?
No, not that I know of.
Counsel, you can address bond.
Thank you, Your Honor. And just for the court to be clear, I think there might have been mention of a failure to appear for sentencing in 30th. I'm not sure the accuracy of that, but just wanted to make the court aware because that's what he indicated to me earlier this morning. Your Honor, I asked for a personal recognizance bond in this matter. This is a allegation of UTA and AgDV that happened 4 months ago. This appears to be the only issue he's had, or the only allegation he's had in the last several months. He's just started a job a few weeks ago at a new chicken spot, as he mentioned earlier. He's been in Lansing his entire life, has all Lansing ties. He's moving in with his mom. He indicated to me he's be staying with the mom on Star Avenue. He's not going back to Wilson. We kind of had a very clear discussion about everything. He's been calm, cool, and collective the entire time. I trust that his ability to appear in court and not cause any issues is not going to be an issue, Your Honor. So as for a cash bond, if not a very low cash surety bond. Thank you.
Well, Mr. Annette, if you trust it, then I guess I should too, then, right?
You're the judge at the end of the day, Your Honor.
Thank you. Okay, sounds good. I agree. This is a matter that allegedly took place a while back. I don't know what happened to it. No, it's my color coded thing that usually sits right there. I don't know what happened to it. I'll grant the request for personal recognizance bond. Bond is set in the amount of 1,000 personal recognizance. There will be a no contact order in place for the protection of Ms. Farr. You're not to have contact directly or indirectly. You're not to be within 1,500 feet of wherever she lives, works, or goes to school. You understand that?
Yes, ma'am.
Okay, you're not to travel outside the state without prior approval of the court. That's the sheet that I'm looking for, actually. And you're not to use or possess alcohol or drugs without a valid prescription, and you're not to possess a firearm, ammunition, or any dangerous weapon while you're out on bond. You do need to report to pretrial services within 48 hours of your release. Do you have any questions at this time?
No,
Any additional matters for the record?
Yes, Your Honor. Are you able to tell if he has any other holds?
I
Any
don't
holds?
see that he has anything else pending. The only thing I see, let's see. Well, what's going on in this 2024?
Shows he has a hold on Clinton County.
Okay.
Okay, yeah, he has a hold of Clinton County, so. Sounds like
Thank
they'll
you.
be heading over there next. Any additional matters for the record?
Nope. Yeah, Mr. Flores, remember everything we talked about, right?
yes,
All right. Thank you. Make sure you call pretrial services when you get out.
okay.
All right.
Thank you, you're all set. You know what I'm talking about? Yes. That's laminated? I believe so. Yeah, there was one on my stuff down here, but it's grown legs somehow. Oh, actually, Mr. Flowers has another file. But he's.
Your file.
Was that the 30th one I mentioned?
No, these are both this court. This is file number 25-01441. Let's see here. He also has 21 L2689741. He has 2 L2689742. I don't know what you're talking about for 30th Circuit. Is there supposed to be a controlled substance? Am I missing a file? Oh, okay, there we go. Okay, also I see 24-03537. Oh, okay, let's see here. He is in bench warrant status. He's not eligible for personal recognizance bond. I guess our trust is not going too well right now, Mr. Ned. Okay, so in the previous file, this matter will be amended to 1,000 cash surety on that file. And 24-03537. I think I asked, did I ask, is there any other court dates pending? The answer was a no. Weird. You definitely have some other matters pending. It looks like you were supposed to be before the court back in December. Actually, January 14th, you were supposed to be before Judge Flores. Then you never showed up. So you've been in bench warrant status since then. What happened? Did you forget you had court?
Yeah, yes, ma'am.
How was that? You posted a bond, you had a bondsman. So that means it was forfeited.
I forgot I had court.
You forgot you needed to be sentenced? This is a probation.
Yeah.
Failure to. Okay, as indicated on the bench warrant signed by Judge Flores, I'm going to attach a bond to this, 3,010%.
And yeah, that's on the circuit court file.
I don't have any circuit court files. I don't understand why you keep asking me about a circuit court file.
I'm sorry.
We would never have a circuit court file here. We'd only have the district court.
Sorry, this is my second time.
No, this is a matter he was supposed to be sentenced on. And it looks like he failed to appear for sentencing in January 14th after taking a plea to amended count 1, use of methamphetamine.
Okay, that sounds right. That's why he did inform me of that this morning, Your Honor.
And he probably was supposed to report to probation and probably did not do that. Let me see what the bench warrant indicates. I don't know why all that noise is necessary. Failed to report to probation within 48 hours. So when you took your plea, the court advised you that you had needed to report to probation within 48 hours of your release. You failed to do that. So you will be remanded to meet with probation.
Okay,
And then after they have completed your pre-sentence interview, your bond in that matter will convert to 3,010%.
okay.
Your Honor,
Yes.
would you be open to making the 1,000 cash ready at 10% or no? Since he's going to be unable to likely set $300 in the benchmark file.
I'm just getting exactly what Judge Flores put in the paperwork, so he can make that motion before Judge Flores.
Okay, understood.
Okay, let's see, as it file 25-01441, it's being charged with domestic violence. The allegations of that order about May 13th, 2025 at 3866 Wilson Avenue. He allegedly committed the act of assault and battery upon a Nicole Farr, an individual with whom he had a dating relationship contrary to MCL 750.81. Again, that's a misdemeanor. Maximum penalty is 93 days and $500 in fines, and a consecutive sentence may be imposed under the law. You've been advised of your rights to trial and your right to counsel. We will note that you're requesting a public defender on this file as well and enter a plea of not guilty on your behalf. You are scheduled in this matter to have a pre-trial before Judge Flores on Tuesday, May 27th at 9:30 in the morning. Did you receive a notice to appear for that?
Yes,
Bond in this matter is set at 500 cash surety with GPS tether. There's a no contact order in this file as well. You can't have contact with Ms. Farr, not directly, not indirectly. No calls from the jail. The prosecutor will listen to your jail calls. You understand that?
yes.
The other two files are city files. One is a failure to pay. It's a careless driving you owe $282 on. It's from 2021. Looks like you had some show causes and you failed to appear. When are you paying that?
As soon as possible.
That's the plan. I need a date though.
June 5th.
Okay, if you don't pay by June 5th or return to the court to request an extension, a warrant will issue on that file. Let's see, the file number
Okay.
ending in 741, you failed to appear. Again, for a pre-trial for failure to display an operator's license. That matter is going to be reset. It is for June 23rd at 9 a.m. One, two. Looks like there's about 4 failure to appears on this file. Bond is $200 cash only. Any additional matters for the record?
No, Your Honor, thank you.
Okay, you're all set. On the record in the matter of the state of Michigan versus David Coker. This is 25-01444FT. Parents, please.
Good afternoon, Your Honor. Sorry, go ahead, Mr. Blanchard.
Good afternoon, Your Honor. Josh Blanchard on behalf of Mr. Coker.
Good afternoon, Your Honor. Kelly Megacy, Assistant Attorney General.
Today was the date scheduled for an arraignment for Mr. Coker, who is present from Ingham County Jail. Is that correct? Are you Mr. Coker?
Yes, ma'am. Yes, Your Honor.
I've never seen a complaint like this before.
That makes two of us.
I've never seen a complaint like this before. I'm not really sure what's going on here.
Judge, our office, if you're referencing, I guess I don't know which part you're referencing.
The parts that precede count one.
Yeah, that's pretty standard in my division.
Which division are you in?
Financial crimes.
Okay. Okay, is David Wayne Coker Jr., correct?
Yes, Your Honor.
Okay, I have a felony complaint here. It alleges a date range of December 19, 2022 to January 9, 2023. It says here the complaining witness says that on the date and location described above, counsel, you can have to direct me where the location is.
So I just got this from the clerk's office. It seems count one starts on, oh, you mean the location of the allegations?
Well, you wouldn't be
Yeah.
able to help me with this because you didn't draft this, but
Right.
it says on the date and location noted above. The only location I see above would be 511 Wilcox Parkway.
I'm sorry, Judge, did you ask me a question?
Yes, I did. I'm trying to understand the language that precedes the count. And it states that the complaining witness says on the date and location described above. When I look above, I only see one location, and that's his address.
Yeah, and Judge, it does say Lansing. I believe there's no, I acknowledge that there's no address, but it does say
Okay.
City of Lansing.
Okay, sounds good. Okay, so the complaining witness says that on the date and location described above, that being City of Lansing, Ingham County, State of Michigan, contrary to law, through a pattern of racketeering activity committed larceny by false pretenses against the Michigan Department of Health and Human Services, also known as MDHHS, and or the nonprofit Complete Health Park, CHP, hereinafter, and embezzled funds from CHP. The defendant also unlawfully used or mishandled public money on the date and location described above. In July of 2022, the Michigan State budget for fiscal year 2023, Act number 166, Public Acts of 22, was signed into law. The 2023 budget included Section 1996, a $25 million grant for a community health campus pilot project. The Section 1996 grant was an earmark or legislative directed funding for a local project in Clare County, Michigan. The Section 1996 grant was assigned to MDHHS for administration. The allegations are that the defendant incorporated Complete Health Park, CHP, a domestic nonprofit corporation, on June 2nd, 2022. The defendant was listed in documents as a director and sole member of CHP. CHP's Section 1996 grant proposal was submitted to MDHHS on October 10th, 2022. No other nonprofit corporation submitted proposals. The first CHP Board of Directors meeting was held on October 30th, 2022. The defendant was present. On October 30th, 2022, the CHP board gave defendant authorization to open bank accounts and or engage in financial transactions for CHP. On November 2nd, 2022, the CHP board voted to approve a contract with the independent contractor IW Consulting LLC, hereinafter known as IWC, to manage CHP. Defendant was the owner registered agent for IWC. Defendant used his business entity to bill CHP for purported consulting and project management services. CHP's contract agreement with IWC provided compensation for project management fees in the amount of 7% of the total project cost for the project, and provided hourly compensation for consulting services and project management fees of $200 per hour. The grant agreement signed by the defendant capped the salary amount that one person can be paid as part of the project to approximately $2,012, $100. The grant agreement was signed by the defendant and MDHHS on December 15th, 2022. Defendant was MDHHS's contact person for the project and the CHP representative who handled the distribution of the Section 1996 grant money to CHP. Defendant did not disclose to MDHHS that he was the owner registered agent for IWC, or that he would receive any payment from the project through IWC. The conflict of interest and code of conduct section of the grant management signed by the defendant and MDHHC required that the grantee abide by and be subject to the provisions of 1968 Public Act 317, Contracts of Public Servants with Public Entities Act as amended, and 2 CFR 200.318C1. The grant agreement specifically prohibited holding or acquiring an interest that would conflict with the agreement and doing anything that creates the appearance of impropriety and with respect to the award or performance of this agreement. This section also references 1973 Public Act 196, that is Michigan State Ethics Act, as in the negotiation and execution of contracts as amended, that is, which states in the relevant part, number 7, except as provided in Section 2A, a public officer or employee shall not participate in the negotiation or execution of contracts, making of loans, granting of subsidies, fixing of rates, issuance of permits or certificates, or other regulation or supervision relating to a business entity in which the public officer or employee has a financial or personal interest under MCL 15.3427. The defendant submitted a financial status report dated December 19, 2022 to MDHHS for a time period of December 1st, 2022 through December 31st, 2022, and included invoices showing 2 transactions between IW Consulting and Complete Health Park. An invoice dated December 5th, 2023 for $182,200 from IWC to CHP, and an invoice dated December 31st, 2023 for $638,432 from IWC to CHP. The defendant did not disclose his role in IWC to MDHHS prior to or at the time of the FSR's submission, thereby defrauding Michigan Department of Health and Human Services, Michigan Department of Health and Human Services relied on this non-disclosure to disperse grant funds. The defendant defrauded CHP by submitting the two fraudulent invoices for $182,200 and $638,432 for the period December 1st, 2022 through December 31st, 2022, knowing he did not and could not have performed consulting work amounting to either expense. The defendant approved the invoices payment to his own company, doing so on the day that FSR was submitted. On January 9th, 2023, CHP received the first installment of funds allocated for the Community Health Park project in the amount of $9,941,089.16 from the state of Michigan. Immediately following this deposit into CHP's bank account, defendant wired $820,632 from CHP account to IWC account. Following this transaction, defendant transferred hundreds of thousands of dollars into his personal bank account, and the defendant used the money to purchase personal possessions, including vehicles, firearm accessories, and precious metals, among other things. Defendant used his position as an agent of CHP to convert money belonging to CHP to his own use, enriching himself at CHP's expense. Count 1, the defendant is charged with criminal enterprises, acquire, maintain, alleging that he did knowingly acquire or maintain an interest in or control of IW Consulting, a limited liability company organized in the state of Michigan, and or an organization, association, other legal entity, or a group of persons associated in fact, and did so directly or indirectly through a pattern of racketeering activity, consulting or consisting of two or more of the following incidents of racketeering, to wit, number 1, on or about December 19, 2022, in Ingham County, Michigan, defendant did commit and or aid or abet in the commission of the following offense of financial gain, to wit, did with the intent to defraud or cheat, make or use false pretense, to wit, the transaction between IW Consulting and Complete Health Park. 1, an invoice dated December 5th, 2023 for $182,200 from IW Consulting to Complete Health Park, and 2, an invoice dated December 31st, 2023 for $638,432 from IW Consulting to Complete Health Park. The defendant approved both invoices on December 19, 2022, but did not disclose his role in IW Consulting to MDHHS prior to or at the time of the FSR's submission. The defendant used the false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing of service having a value of $100,000 or more, contrary to MCL 750.2187A. Number 2, and on or about December 19, 2022, in Ingham County, Michigan, the defendant did commit and or aid or abet in the commission of the following offense for financial gain, that being did with the intent to defraud or cheat, make or use a false pretense, to wit, the defendant submitted an invoice dated December 5th, 2023 for $182,200 from IWC Consulting to Complete Health Park, while knowing or having reason to know that IW Consulting had not done $182,200 worth of services to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having the value of $100,000 or more, contrary to 0.2187A. And that on or about December 19, 2022, in Ingham County, Michigan, the defendant did commit and or aid or abet in the commission of the following offense of financial gain, that being that he did with the intent to defraud, cheat, or make or use a false pretense, that being defendant submitted an invoice dated December 31st, 2023 for $638,432 from IW Consulting to Complete Health Park, while knowing or having reason to know that IW Consulting had not done $683,432 worth of services to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $100,000 or more, contrary to MCL 750.2187A. And that on or about January 9th, 2023, in the Ingham County, Michigan, the defendant did commit or aid or abet in the commission of the following offense for financial gain, that being the agent, servant, or employee of Complete Health Park. The defendant did convert to his own use without the consent of his principal, $182,200. That's money belonging to his principal, having value of $100,000 or more, that came into his possession or under his charge or control by virtue of his relationship with the principal, and that this was done contrary to MCL 750.1744. And that on or about January 9th, 2023, in Ingham County, Michigan, the defendant did commit or aid or abet in the commission of the following offense for financial gain, to wit, being an agent, servant, or employee of Complete Health Park. The defendant did convert to his own use without consent of his principal $638,432, money belonging to his principal, having the value of $100,000 or more, that came into his possession or under his charge or control by virtue of his relationship with the principal, and that this was contrary to Michigan compiled law 750.1744, which have the same or substantially similar purpose, result, participant, victim, and method of commission, and which amount or pose to or pose threat of continued criminal activity, contrary to MCL 750.159I12. Count one is a felony. The maximum penalty is 20 years and or $100,000 in fines, criminal forfeiture of proceeds, substituted proceeds, and instrumentalities of racketeering listed on attached notification. A court may order court costs and cost of investigation and or cost of prosecution. Criminal enterprises notice of intent to forfeit property pursuant to Michigan compiled law 750.159J5. The following property was used in the course of, intended for use in the course of, or derived from, or realized through the racketeering conduct alleged herein, and upon conviction under MCL 750.159I is subject to criminal forfeiture. Number one, vehicles owned by or registered to David Coker, specifically including a 2023 Honda ORV, would have been number ending in 00109. 2015 Buick LaCrosse, the number ending in 32210. 2016 Ram 3500, then ending in 3885. 2024 Chevrolet Trax, then number ending in 3582. Number two, coins and precious metals purchased from Caps Coins on January 18, 2023. There is a 10-ounce silver bar Engelhard, another 10-ounce single bar Engelhard cord, 100-ounce silver bar, 61-ounce silver rounds, 1 and 1/10-ounce proof American Gold Eagle, 3 1-ounce platinum bars, 2 50-ounce silver bars, 5 1/10-ounce RCM gold bars. Items purchased from JM Bullion on January 17, 2023, including 2020 1-ounce American Gold Buffalo coin, a 2021 American Gold Buffalo coin, a 2022 1-ounce American Platinum Eagle coin, 100,000-ounce Silvertown Pony Silver Bar, new, 51-ounce American Silver Eagle coins, one 1-ounce silver bullet, 45 caliber, new. One 2-ounce silver bullet, .308 caliber, new. One 5-ounce silver bullet, 12 gauge, new. Items purchased by David Coker from Sig Sauer on January 16, 2023, including a Sierra 6 bid rifle scope, black in color, digital ballistic reticle, and there's an SKU number ending in 5111. A Bravo Battle Pack Bravo 4x32 millimeter horseshoe dot, black in color, SKU number ending in 762. An Echo or X03 thermal flex sight, SKU number ending in 001. A Bravo 5 battle sight horseshoe dot reticle, black in color, SKU number ending in 101. U.S. currency in possession of David Wayne Coker Jr. or found at the location or vehicles listed. The balance and securities of any and all Horizon accounts, as well as any safety deposit boxes associated with any and all individual accounts of David Wayne Coker Jr., joint accounts of David and Sarah Coker, Complete Health Park business account, and IW Consulting LLC business and checking accounts, including the Complete Health Park business account ending in 7376, IW Consulting LLC business account ending in 8142, IW Consulting LLC business checking account ending in 8155, David and Sarah Coker personal account ending in 8168. The balance and securities of any and all Michigan State University Federal Credit Union accounts, as well as any safety deposit boxes associated with any and all individuals and individual accounts for David Wayne Coker Jr., joint accounts for David Wayne Coker Jr. and Sarah Coker, and IW Consulting LLC business and checking accounts, including David and Sarah Coker's personal account ending in 5033, David and Sarah Coker personal account ending in 8835, and then IW Consulting LLC business account ending in 6394. Any additional items or accounts that become known during the course of the investigation and or search and or arrest regarding the listed location and individual are also subject to forfeiture. Count 2 reads false pretenses, $100,000 or more, alleging that Mr. Coker did with the intent to defraud or cheat, make or use false pretense, to wit, the defendant submitted a financial status report, that's an FCR, dated December 19, 2022 to MDHHS, that included invoices showing 2 transactions between IW Consulting and Complete Health Park, an invoice dated December 5th, 2023 for $182,200 from IW Consulting to Complete Health Park, and 2, an invoice dated December 31st, 2023 for $638,432 from IW Consulting to Complete Health Park. Defendant did not disclose his role in IW Consulting to MDHHS prior to or at the time of the FSR's submission. The defendant used this false pretense to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $100,000 or more, contrary to MCL 750.2187A. That's a felony. Count 2 is punishable, maximum penalty 20 years in prison and or $35,000 in fines, or 3 times the value of the money or property involved, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. Count 3, false pretenses, $100,000 or more, as well as count 4, false pretenses, $100,000 or more. Both allege that the defendant did with the intent to defraud or cheat, make or use a false pretense. That being, the defendant submitted an invoice dated December 5th, 2023 in count 3 for $182,200. And in count 3, invoice that was dated December 31st, 2023 for $638,432. Both while knowing or having reasons to know that IW Consulting had not done in count 3, $182,200 worth of work, and count 4, $638,432 worth of services to obtain from a person money, personal property, or the use of an instrument, facility, article, or other valuable thing or service having a value of $100,000 or more, and that this is contrary to MCL 750.2187A. Count 3 and 4, felonies, maximum penalty in both 20 years in prison and or $100,000 in fine, criminal forfeiture of proceeds, substituted proceeds, and instrumentalities of racketeering listed on attached notification. And the court may order court costs or cost of investigation and or cost of prosecution. Counts 5 and 6 are both embezzlement, $100,000 or more, alleging that being an agent or servant or employee of Complete Health Park did convert to his own use without the consent of the principal. In count 5, $182,200. In count 6, $638,432. Both being money belonging to his principal, having a value of $100,000 or more that came into his possession or under his charge or control by virtue of his relationship with the principal, and that this was contrary to Michigan Compile Law 750.1747. Count 5 and 6 are both felonies, maximum penalty in each count 20 years in prison and or a fine up to $50,000 or 3 times the amount embezzled, whichever is greater. A consecutive sentence may be imposed for any other conviction if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. To impose 3 times the value, the defendant must admit the amount or it must be determined by a trier of fact. Lastly, count 7 is public money safekeeping, alleging that the defendant did commingle public monies with his own and or under a pretext used or allowed to be used money or public monies for the purpose other than that allowed by the December 2022 grant agreement, and or willfully or corruptly draw or use or issue a warrant, order, or certificate for the payment of public money in excess of the amount authorized by the grant agreement or for a purpose not authorized by the grant agreement, contrary to MCL 750.490. Count 7 is a high court misdemeanor. The maximum penalty is 2 years or $100,000 in fines. Okay. Do you have any questions about the charges that was read?
No, Your Honor.
You have the right to be represented by an attorney. You have retained counsel for the purposes of this litigation. Is that correct?
That's correct, Your Honor.
Okay. Okay, you have the right, if you could not afford an attorney, to make a request to have the public defender's office represent you at the expense of the public. The court will note that you are declining representation by the office of the public defender, that you have retained counsel. Counsel, can you spell your name for me?
Yes, sure. BLANCHARD. Our number is 72601. No, I'll get it up here. It's on file. We just things move quickly.
I believe so. Okay, sounds good. Okay. You have several rights, Mr. Coker. One is your right to the presumption of innocence. You're innocent until proven guilty. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you, but you do have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will make its way all the way to a jury trial. Prior to going to trial, you have the right to a preliminary examination. The purpose of the preliminary examination is for you to require the prosecutor, which is the Office of the Attorney General, put forth on the record evidence that will support that they have sufficient probable cause that the felonies that you are being charged with were committed, and then probable cause to charge you as the person who committed the felonies. Do you have any questions so far?
No, Your Honor.
You're currently scheduled to have a probable cause conference before me, Judge Kristen Simmons, Friday, May 23rd at 8:30 in the morning. And you have a preliminary examination before me in person at the court, Friday, May 30th at 9 o'clock in the morning. You have the right to have that exam within 21 days of today's date, because that's the date you're being arraigned, unless you waive the timeline for whatever reason, or the court finds good cause to go beyond the 21 days. Do you have any questions at this time?
No, Your Honor.
Okay. You have the right to have a jury trial. Again, you have the right to the presumption of innocence. Anything you say again and anything you put in writing can be used against you. At the time of your trial, you can maintain your silence as well and not have that silence be used against you. However, you can waive your silence and testify at your trial if you like. You have the right to call witnesses that will give testimony on your behalf. And you have the right to see, hear, and question or cross-examine any witness called by the state against you at your trial. Do you have any questions about that?
Oh, Your Honor.
Okay, what is his home address?
511 Wilcox Parkway in Clare, Michigan, 48617.
Okay, and the locations indicated in the complaint, that's his only employment, or is there other employment?
I don't think there's a, oh, I'm sorry, you're referring to complete health.
Yeah, I'm
It's not-
wondering if that's his employment. Where's he employed?
He's employed as the director of the Clare Chamber of Commerce. There's Complete Health Park, there's a stop work.
Director of
Clare Chamber of Commerce. It's not
Clare
right.
Chamber of Commerce, okay. His phone number.
Mr. Coker, could you provide your phone number?
Yes, sir. It's 517-996-2099. That term.
He's not currently on bond for anything else, correct?
He's not on bond for anything, and I don't believe he has any criminal history.
I don't see anything prior. Is the AG making a record as it relates to bond today?
Yes, Judge, but prior to that, Judge, as to count 4, the false pretenses with the referencing the invoice for $638,000, $432,000, excuse me. This is, I will have to amend the complaint because the penalty should say 20 years and or $35,000 or 3 times the value. It has the racketeering penalty and it should not. So I wanted to note that mistake for the record and that the complaint will be amended. But as it relates to bond, Judge, on behalf of the people, I'm making 2 requests. One, that the court order defendant to surrender his passport. It's my understanding that the defendant did provide his passport to one of the agents today. So they have that in their possession, but I am asking that the court order it and that the defendant not be allowed to travel out of state without the court's permission, and that the defendant not have contact with any of the witnesses or engage in discussions about the case with any of the witnesses. Beyond that, I take no additional position as it relates to bond, Judge.
Okay, you said that he did turn over his passport to an agent today?
He did.
Okay.
I was going to say, I've seen the return and tabulation. They seized it pursuant to the search warrant, notwithstanding that it wasn't authorized by the search warrant. It's on the return and tab.
Okay, thank you. Counsel, you can address bond.
Thank you. So my client's a lifelong resident of Clare County. He was born there, graduated from high school there. He left for a few years for work purposes and went back. He owns a home there. He's employed there. He's an elected official there. He has 3 grown children that live in the state. One of them in this area, one at his home. His wife and children are in the courtroom today. He's got good family support, no criminal history. He does have some health issues that are being managed effectively on the outside. I think this is an appropriate case for a personal recognizance bond. I'd ask the court to impose it. We've been in communications with the office of Inspector General and the Attorney General's office for years now. I was a little surprised that they executed an arrest this morning about giving us a heads up, but they chose to do it that way, despite us being in contact for years. In any case, he quickly got me on the phone, and we're here. He's going to answer to this and defend it. So I'd ask for a PR bond. I'd also ask on, it's maybe a big ask, but on the bond condition for travel, he had an anniversary trip scheduled with his wife for May 25th through June 1. He was frankly going to be out of the country. So he was hoping to do that. I acknowledge that might be a big ask.
That's a big ask. It's not going to be granted. I am going to order that his passport be surrendered during the pendency of this matter. I don't see any prior criminal history. This is not an allegation of violence. So I think personal recognizance bond is appropriate. So I will grant the request. Bond will be set in the amount of $100,000 personal recognizance bond. While out on bond, there is a no contact order as it relates to your inability, sir, to have discussions with any of the potential witnesses. I don't have a list of those witnesses, so unfortunately I can't put those names in a official no contact order, but if the prosecutor would like to provide that to the court, we can make sure that goes into our order and name specifically what individuals he should be ordered not to speak to.
Yes, Judge, and I'll make sure that Mr. Blanchard is part of that, that information. Is the court asking me to do that now, or email that to the court?
Yep, you can email that to the court, and then my staff will get a new PA 53 order updating with those names.
Thank you, Judge. I'll make sure Mr. Blanchard is included.
No problem. While out on bond, no problem. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of this court. You're not to, again, have any contact with the potential witnesses. You're not to use drugs or alcohol. And you must report to pretrial services within 48 hours of your release from custody. You can get the information on how to report from the jail, okay?
Yes, thank you, Your Honor.
Do you have any questions about your bonds at this time?
No, ma'am. No, Your Honor.
And counsel, I presume that given the condition that he can't travel out the state, there may be a future request for travel out of the country, that is. There may be a request for travel out the state. You can route that through pretrial services. They'll get it to the court.
Thank you.
Thank you. Any additional matters for the record?
No, thank you.
Thank you. You're all set.
Thank you.
Thank you.
This is the matter of the state of Michigan versus James Sharp, 25-00517FY. Parents, please.
George Anid, Your Honor, Assistant Public Defender, representing James Sharp for purpose of preliminary purposes only.
Okay, Mr. Sharp, I have here another file. Where are we? Oh, I got it. Mr. Sharp, I have here in file number ending in 517 a complaint. The allegations are that on or about March 20th, 2024, that you did allegedly in count 1 commit the act of stolen property, receiving and concealing $100,000 or more, but less than $20,000. The allegations are that on or about March 20th, 24 at 624 East Holmes Road, Lansing, Michigan, 48910, you did buy, receive, possess, conceal, or aid in the concealment of a MacBook Pro, iPad, jewelry, clothing, and other home electronics and household items stolen, embezzled, or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted, and the value of the property was $1,000 or more, but less than $20,000, contrary to MCL 750.5353A. Count 1 is a felony. A maximum penalty is 5 years and or $10,000 or 3 times the value of the property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. You understand the charge and the maximum penalty?
Yes, I do, Your Honor.
Okay, you have the right to counsel. You're represented today by Mr. Annette for the purposes of your arraignment only. You have the right to have an attorney represent you throughout the pendency of this criminal prosecution, and the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand that, right?
Yes, Your Honor.
Okay, you have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. But if you stand mute, the matter will go all the way to a jury trial. You have the right to have a preliminary examination within 21 days of today's date, unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on May 23rd at 8:30 in the morning. You have a preliminary examination before Buchanan on Friday, May 30th at 9 o'clock. You must appear in person for your preliminary examination. You have the right to hold your examination and require that the prosecutor put forth sufficient evidence to establish probable cause that the felony was committed and probable cause sufficient to charge you as the person who committed the felony. Do you have any questions?
No, Your Honor.
You're innocent until proven guilty, and you can take this matter to trial and require that the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You can maintain your silence at trial and it cannot be used against you, or you can waive your silence and testify at your trial if you'd like. And you have the right to subpoena witnesses that can testify on your behalf, and the right to cross-examine or question any of the witnesses called by the prosecutor's office. Let's see. Is he requesting the public defender's office to represent you, to represent him, that is?
Yes, Your Honor.
Okay. The court will enter a plea of not guilty on your behalf. And note that you are requesting the public defender. Are you employed, sir?
Yeah, my brother, I'm employed by Lupe Mendoza Construction.
What's the name of the construction company?
Mendoza Construction.
Speak up a little louder. We got some music over here.
Mendoza Construction.
Okay.
Mendoza Construction.
Okay. What's your home address?
567 East Mount Hope, Lansing, Michigan, 48910.
Your phone number?
Area code 517-488-5214.
Are you on probation or parole?
No, not yet.
You said not yet.
I'm not on probation yet.
Your Honor, he has a sentencing in July for, I believe, a domestic violence under 4A status, is what I was told. In Eaton County.
Okay, I do see one here. I also have T0027737701. You owe $90 for an expired meter. When are you gonna pay that?
Upon release, I'll pay it within 30 days.
Okay, I'll note you'll pay within 30 days of your release.
Thank you.
Counsel, you can address bond.
Thank you, Your Honor. I had the opportunity to speak with Mr. Sharp this morning. He has been in Lansing for a majority of his life. He has one 17-year-old with special needs that lives with him here on Mount Hope, as Anderson provided earlier. He is currently married, is starting a job with Mendoza Construction very soon. This is a non-assaultive case allegation. I believe he has no other criminal history besides the 4A status that may enter soon. I believe a personal recognizance bond is more than appropriate here, so he can be released, make some money, so he can pay those fines and costs that he got going on. And these are considering the two factors of flight risk and public safety. Thank you.
Okay, bond is set in the amount of 1,000 personal recognizance. While out on bond, you have the following conditions. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess drugs or alcohol. You're not to travel outside the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release, and there is a no contact order for Gail Fisher. You're not to have contact directly or indirectly with Gail Fisher. Do you understand that?
Yes, Your Honor, I do.
You have any questions about any of your bond conditions?
No, ma'am. No, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir.
Thank you, Your Honor. Thank you.
For the record, in the matter of the state of Michigan versus Jerry Gary 25-01440, appearance, please.
Good afternoon, Your Honor. George Ed, Assistant Public Defender, representing Jerry Gary for purposes of arraignment only today.
Okay, Mr. Gary, you can step forward a little more, please. I have a felony complaint here. It alleges that on or about May 14, 2025, that you did allegedly commit the act in count 1 of robbery unarmed, and that on or about the 14th of May, 2025 at 500 East Saginaw, Lansing, Michigan, 48906, that you did in the course of committing a larceny of bacon, sausage, smoky links, use force or violence against a person present, that being a Jennifer Cunningham, and that this was contrary to MCL 750.530. Count 1 is a felony. The maximum penalty is 15 years in prison. Your DNA is to be taken upon arrest. There is an habitual offender fourth offense notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about April 30th, 2025, he was convicted of the offense of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams in violation of MCLs 333.7403-285 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about September 25th, 2023, he was convicted of the offense of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams in violation of MCL 333.7403-285 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about April 13th, 2022, he was convicted of the offense of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams in violation of MCL 333.7403-285 in the 30th Circuit Court for Ingham County, State of Michigan, and therefore the defendant is subject to the penalties under MCL 769.12 that enhances the penalty of life in prison if the offense as if, life if the offense is a penalty of 5 years or more. 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Mr. Gary, do you understand the charge that was read in the maximum penalty?
Yes, ma'am.
You have the right to counsel. Mr. Annette is representing you for your arraignment only, but you have the right to have an attorney represent you throughout this criminal prosecution, and the right to be represented by an attorney if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request for the public defender's office to represent you at the expense of the public. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. This matter will go to a trial if you stand mute. You have the right in this matter to have a preliminary examination before you proceed to trial. And you have the right to have that within 21 days of today's date unless you waive the timeline or the court finds good cause. At the time of the exam, you have the right to require the prosecutor establish that they have sufficient probable cause that the felony you're being charged with was committed in probable cause sufficient to charge you as the person who committed the felony. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan, Friday, May 23rd at 8:30 in the morning. You have a preliminary examination before Judge Buchanan on Friday, May 30th at 9 a.m. in person at the court. Did you receive a notice to appear before Judge Buchanan?
Yes, ma'am.
Is he requesting the public defender's office?
Yes, Your Honor. Yes.
Court's gonna enter a plea of not guilty on your behalf. What's your home address?
I'm currently homeless right now, but I've been, going house and house, but I'm gonna get it together.
Where are you staying right now? Where do you sleep?
I was staying with a friend of mine.
Where's your friend staying?
South side of Lansing.
You don't know the address?
I don't know the exact address, but I know it's off of Holmes. But I would be able to get to court for this matter.
Okay,
I would never.
Do you have employment? I didn't ask you any of those questions. Do you have employment at this time?
No, I'm working on getting my disability.
Okay. Do you have a phone?
Not currently, but I should get an Obama phone or something.
We know that you're out on bond because I read that in the complaint. And so are you on probation or on parole?
Oh, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. Based on the facts or the circumstances surrounding Mr. Gary, I'm asking for a low bond, Your Honor. One reason was so he can able to be released. He has no income. He has no money. He is staying from place to place. I believe he really wants to go back in the community to get his, start moving with his SSI, try to get a phone, try to rehabilitate himself to the best of his abilities. My understanding, based on my communication, that he may have been released from a sentence not too long ago. So this is kind of just hindering him a little bit. I asked for whatever is reasonable under the circumstances, Your Honor, based on the factors that the court looks at.
I have a pretrial services bond recommendation here. States here that the assessment identifies the defendant having a risk score of high. They indicate violent felony offense and that release on his own recognizance is not recommended, to state that a check of the available records does show the defendant has more than 2 qualifying failure to appears, and that the incident in question, according to the police report, that is, the defendant was arrested after law enforcement was dispatched to the area for a troubled subject who was jumping in the middle of the road in front of cars. The defendant was also a suspect in a robbery that occurred at a Quality Dairy on the same evening, which is the unarmed robbery allegation that I just arraigned him on. The report also lists a litany of other criminal convictions from 2000 to 2024. There's at least one for each year, and 2019, 2022, 2023, he's had multiple convictions. So I agree that personal recognizance is not appropriate in this matter. Bond will be set in the amount of 5,000 cash surety. While out on bond, you have the following conditions. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. There will be GPS tether ordered. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to have contact with a Jennifer Cunningham, nor are you to be at the address within 2,000 feet of 500 East Saginaw in Lansing, Michigan.
Yes, ma'am. Ma'am, can I say something, please?
Not at this time.
Mr. Gary, remember what we talked about.
Yes.
You'll see your attorney in 9 days. Or sooner.
Okay. Once bonded, if you do post bond, that is, you need to report to pretrial services within 48 hours of your release. Do you have any questions about that, sir?
No, ma'am.
Okay, now do you have a question or something you wanted to state?
No, I wasn't saying anything. I was just saying that, I was homeless and I'm not, coming up with any excuses or anything like that. Only thing I'm saying is that if you check my record, I just did a year in Ingham County Jail. So I just got out the 29th of April. Like, I was just homeless. That's it. I'm not a violent person, nothing like that. I can't even afford $100 bond, 10% if I could. I just need some help.
Mr. Gary, we can address bond, or your attorney will be able to address bond on the 23rd. Like as we talked about, just keep doing what you're doing. You're doing the right thing. Just keep going.
Right.
Mr. Gary, I don't know. I don't addressing your bond on the 23rd. It doesn't change the factors that were stated here on the court. And I recognize that you were just released from custody, which is concerning that you're already back before the court. But it appears that you just also got a recent conviction, because it says that you have a conviction from April 30th, 2025. Today is only 2 weeks after April 30th.
So you got.
In addition to that, in addition to that, I see 2025, a conviction for controlled substance possession, 2024, retail fraud, 2nd degree, 2023, assault and battery. The list goes on, sir. You had 5 convictions in 2022. And so But in this particular case, the allegations are violent in nature, in that there was an unarmed robbery where some force was used, and then officers were responding due to concerning behavior of allegedly your activity in the public. And so you're currently at least out on bond, which would mean you're not appropriate for you're not a candidate for a personal recognizance bond, because you are already under court supervision when allegedly picking up this new case. You'll see.
No, ma'am. No, ma'am, I promise you, I'm not.
Do you have another court date pending?
No, I do not. I do not have no other court date. I'm not on no probation, I'm not on no papers. I served my 300.
You got a conviction on the 30th, and you got sentenced to 14 days, or what happened?
What does it mean?
Okay, very good. You're all set. You'll see Judge Buchanan. You'll see Judge Buchanan at your next court date. You're all set. Okay, State of Michigan versus Willie Rembert, 25-01442 SM, appearance, please.
George and Ed, Your Honor, on behalf of Willie Rembert, if I heard you correctly, for purposes of arraignment only.
Mr. Willie Rembert? Just remember to have a misdemeanor complaint charging you with the allegation of domestic violence. It states here that on or about May 13, 2025, that you did allegedly at the area of 400 South Pennsylvania Ave, Lansing, Michigan, make an assault or assault and battery upon a Layla Simone Royale Ashley, an individual with whom you had a dating relationship, and that this was done contrary to MCL 750.812. That's a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the penalty?
Yes, ma'am.
Okay, you have the right to be represented by an attorney. The public defender's office is representing you today for your arraignment only, but you do have the right to have an attorney at all of your court appearances, and the right to be represented by an attorney if you're questioned by the police. Do you understand that?
Yes, ma'am.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to a trial. You have the right to jury trial and the presumption that you are innocent, and you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element of the charge or charges being brought against you beyond a reasonable doubt. You're currently scheduled for a pretrial before me, Judge Kristen Simmons, Monday, June 16th at 8:30. Did you receive a notice to appear for that date?
Yes, ma'am.
Again, you have the right to continue to trial and cross-examine or question any witnesses or the accusers that are called to testify against you. You have the right to subpoena witnesses that will testify at your trial on your behalf, and the right to waive your silence and testify at your own trial if you like. Do you have any questions about those rights?
Oh, ma'am.
Is he requesting a public defender?
Yes, Your Honor.
The court will enter a plea of not guilty on your behalf. Are you employed?
Yes.
Where?
I work for my dad at War Masonry.
What's the name of it?
War Masonry.
Okay. Very good. Okay, what's your home address?
3031 South Washington, apartment G6.
And Layla Ashley does not reside there, correct?
Does
You said yes?
she do?
She does
Yeah.
reside there?
Yeah.
Okay, well, where are you gonna live? Because you can't live where she lives.
My mom.
Where is that?
2114 Georgetown Boulevard, apartment 16.
In Lansing, correct?
Yes, ma'am.
What's your phone number?
517-574-0878.
Okay, Mr. O'Neill, did you want to say something?
No, he said it.
Oh, okay. Okay, let's see. Are you on probation or on parole?
No, ma'am.
No. I don't see any other, I don't see any conviction on his criminal record.
Correct.
Just one previous charge of domestic violence that was dismissed. Okay, you can address bond counsel.
Thank you. I think I believe a personal recognizance bond is appropriate in this matter. Mr. Rembert has no criminal history, no criminal convictions. That is, he lives in Lansing. I think he lived in Lansing's entire life, but except for 2 years, about 12 years ago, for family matters. Has one child now with the complaining witness that he takes care of. Is employed. Is a good member of the community. I believe. Simply a PR bond with conditions is more than appropriate. He is very young, and based on our conversations, he'll be appearing for court without issue.
Bond is set at 500 personal recognizance with GPS tether. While out on bond, you're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. There is a no contact order between you and Miss Ashley. You are not to have contact directly, indirectly, through third party, or any other mechanisms. Do you understand that?
Yeah.
I couldn't hear you.
Yes, ma'am.
Okay, you're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription, and you must report to all of your court dates. Do you have any questions about your bond?
So I gotta pay $500 for bond?
No, it is personal recognizance. You do not have to pay
Okay.
anything to get out. Okay, any additional matter for the record, counsel?
Your Honor, yes, we did discuss GPS tether this morning very briefly. That may be a hindrance upon his job. We're not going to contest that today, but would you be open to at least bring that up again back on June 16?
Why would it be a hindrance to his job?
He works at a masonry, I believe, something regarding boots, and it may be interrupting. It was just a conversation we talked about. I believe it's the GPS with maybe the boots that he may be wearing.
I think the concern that I'm having at this time is the allegations of continued contact after a recent breakup. So to ensure the safety of the victim, which is what I have to prioritize versus or over his ability to wear boots, I'm going to have to order the GPS tether at this time. But we can readdress that at his next court date.
Okay, that's exactly
If
okay.
there's no issues, I'll have no problem removing it after his next court date.
You got that, Mr. Rembert?
I got one partner. It's all right. Never mind. That's it. Thank y'all. Have a good day.
Thank you.
Same to you. Okay, this is the matter of the state of Michigan versus Stephen Woody, 25-011, I'm sorry, 1443. Appearance, please.
George Lynn, Assistant Public Defender, on behalf of Mr. Woody for purposes of arraignment only.
Your Honor, Mr. Woody was very cooperative with us this morning, and we were hoping to do him by tablet after everyone else
That's
in
right.
his cell.
Okay. So Woody might get running tomorrow. Let's see. Okay, City of Lansing versus Nathan Kreit, 21-02877 and then 24-02296. Mr. Kright, let's see, you owe money on both of these files.
Yes.
And because you refused to make a payment, even though you were in collections on one of them, we have to put you all the way in jail to deal with the money.
Yeah.
On one file, you owe $288. That was a driving while license is suspended. That it looks like we've been collecting on you for several years. The other file. Started off as a felony. Nonetheless, you owe some restitution, it appears. It says you owe $4,484.98, and you've not made a single payment on the payment plan. Okay, were you recently incarcerated at ICJ?
Yes, I was. Well, not that recently, but about a few months ago.
Okay, when were you released?
Shoot, about 2 to 3 months ago, I think.
Okay, are you working?
Right now I am, but I've only been working there for approximately about 2 weeks.
Where?
It said it was it said shoot, it's all on Cedar and it's shoot, it's slipping my mind right now. It's on Cedar and it said they rent trucks, U-Haul. I'm sorry.
You work at U-Haul?
Yes, I work at U-Haul cleaning trucks out, like when customers are finished with them.
Okay, how long you been there, you said?
I've been there for about 2 weeks. They also only work about like 2 days on the weekend.
Okay, when are you gonna make a payment?
Well, I can make a payment when I get paid next week. That's the first payment I can make.
How much you gonna pay?
Shoot, I mean, I don't know how much I really get paid every because that'll be my first paycheck, but I can at least make a $30 payment if
You don't
if that'll do.
gotta use this pay, you do not have to use this paycheck. You can use the next paycheck if that works better.
Okay, that would work better for me if that's
You're gonna
possible.
pay $30? You're gonna pay $30
Yes.
within 30 days?
Yes, ma'am.
Okay, and then you'll pay $30 per month until paid in full.
That's no problem.
If you don't follow the payment plan, you know what will happen, correct?
Yes, I do.
You get arrested, and you don't need to lose your new job because you got arrested because you didn't pay the $30, okay?
Yes, ma'am.
Okay, I'm gonna have them add this to your collections payment here.
Okay.
Do you have any questions at this time?
Ma'am, I don't.
Okay, you're all set, thank you.
All right, thank you.
You're welcome. This is the State of Michigan versus Tyler Barton, 25-00684. Appearance, please.
George Anid, Assistant Public Defender, on behalf of Tyler Barton, for purposes of arraignment only, Your Honor.
You are Tyler Barton, correct?
Yes, ma'am.
Okay, Mr. Barton, you were previously supposed to appear in court for an arraignment on this file, it looks like. Or maybe he did, it says picture, did he? He did. You did appear for an arraignment for an assault and battery. You were supposed to appear for a pretrial on March 18th. You failed to appear. Why did you not come to your court date?
I was in a mental health facility and then rehab.
Okay. When were you at the mental health facility?
The day before the trial, the pretrial. I mean,
What date was that?
the 17th.
Okay, and then when did you go to rehab?
As soon as I got out of the mental health facility, which was like a week later, I did 28 days in rehab.
Why didn't you come and take care of your warrant after you got out?
I thought it had been taken care of. Like I had talked with like the prosecuting attorney and I thought everything was settled. I was just wrong and I apologize.
You talked to the prosecuting attorney about this file?
Yeah, I think so. I talked to somebody.
Could it have been the public defender that you talked to?
Maybe. I'm not exactly sure.
Okay. All right. Well, the matter is now going to be scheduled for a pretrial before Judge Flores on May 27th at 9 a.m. Okay?
Okay.
And it appears you also were supposed to be here for some bond violation allegations. So I think there's 3 in this file. Let's see here. He would have or should have been arraigned on the March 4th one. I don't understand why it says March 4th. Let's see. Maybe not. Okay, you were not arraigned on this because you were arraigned on the actual charge March 4th. And then allegedly the same date that you were arraigned, there was a violation of the bond condition. So when you were arraigned by the magistrate, you were given several conditions and that included not to commit a crime while released, not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in other conduct that would place any of the following persons or a child of any of the following persons in reasonable fear for bodily injury, that being your spouse, former spouse, individual with whom the defendant has a child in common, a resident or former resident of his or her household. It also stated that you were not to assault, harass, intimidate, beat, molest, wound, or threaten a Kelly Fitzgerald, and that there was a no contact order between you and Ms. Fitzgerald, and that you were not to be within 2,000 feet of wherever she lived, worked, or goes to school. The allegations are that you violated your bond conditions the day that you were arraigned because you went to the address where Ms. Fitzgerald lived shortly after being arraigned and released from jail. The allegations are that you went by and requested some belongings and that she had to request that you leave. So that is a bond violation. I have another allegation of a bond violation from March 14th. Again, alleging that you violated the no contact order, the not to have direct or indirect contact with Kelly Fitzgerald and not to be within 2,000 feet of wherever Ms. Fitzgerald lives, works, or goes to school. The allegations are that you did go by that address on the March 14th date and stayed the night in violation of the no contact order. There is another allegation of a violation of the no contact order, and this is for May 13th, 2025. Again, allegation that you violated the no contact order, that you're not to have contact directly or indirectly with Ms. Fitzgerald. The allegations are that you on May 13th were at the area where the the protected party lives, and that officers were dispatched in reference to a trouble subject complaint. The caller, Ms. Fitzgerald, stated that you were there intoxicated, yelling and threatening her. It looks like you were arrested at that location and transported to the Lansing Police Department for your arraignment today. And so you have the right in each of these violations to be represented by an attorney. Each of those violations are considered a contempt of court proceedings. If you're found to be guilty of violating your bond can be revoked and you can be sitting inside the jail while your assault and battery case works its way through the system. You also could be sentenced on each violation. The maximum penalty for contempt of court is 93 days in jail per violation and or up to $7,500 in fines per violation. Do you understand that?
Yes, Your Honor.
Okay, how does he want to proceed, Mr. Ned?
Not guilty, Your Honor. On all three.
The court will enter a plea of not guilty on your behalf. This will be set for hearing the same date as the pretrial, May 27th at 9 o'clock in the morning. You can address bond.
Your Honor, Mr. Barton has no criminal history. To my understanding, he is single, has one child, lives with his mom right now. It has obviously, as he stated, or not obviously, sorry, has stated that he's been going to rehab and getting treatment for some issues. I believe, to some extent that it's clear that he needs a little bit of help. But it does not indicate that he's a threat to public safety or a concern for assaultive behavior. The three allegations, again, are allegations. One was the allegation of staying the night. That is not assaultive behavior, Your Honor. Went to the address after arraignment. That's not assaultive in nature, Your Honor. Again, all allegations at the area where she lives and was angry or something of that nature. Nothing assaultive, Your Honor. At least to my understanding, he has no criminal history. He has some issues that he needs to take care of on his own. I don't believe jail is appropriate. I'd ask for a personal cognizance bond with a GPS tether if you believe it's needed. If not, a low cash bond, Your Honor, so you can get out and get some things done.
I don't have his criminal history because this was not a fresh arraignment. So I cannot attest to what is on his prior criminal history. But what I do have is a file where the defendant is being charged with assault and battery, which really should be a domestic violence. It sounds like you made a statement that he's living with his mom. He can't live with his mom because that's she's the victim and there's a no contact order. So if he's living with his mom, he's violating his bond. The other issue here is it states here that in the affidavit of probable cause that Kelly Fitzgerald said her son, Tyler Barton, got upset and started punching her multiple times in the face, arm, and stomach, pushed her in her chest, and that when the officers arrived, she had swelling in her eyes. This is his mother. And so you're not going to tell me with a straight face that if these are the allegations that they are true, that there's not a threat to the public. If you're a threat to your mother, you're definitely a threat to the public. There's a level of sanctity that typically comes with your mother. Anyone who would do that to their mother would do that to a stranger, would do that to you and anybody else. Then on top of that, when the court gives him direction and an order that he's not to be at the place where she lives, works, or goes to school for any reason, within hours of him being released from jail, he goes directly there because he does not care about a court order. You know how I believe that he doesn't care about a court order? Because I now have 3 violation allegations of violating the bond, and one being the one from last night. The allegations are threatening in nature. That he was present at her address that he was again being threatening towards her, and she had to call the police. But he had no business being there in the first place because there was a no contact order. I don't believe he believed that this matter was resolved and that he talked to a prosecutor and this was all set. He never showed up to court. And so there's a blatant disregard for court order, and if true, disregard for the safety of his own mother. So he's not getting another personal recognizance bond out of me. He can request that from someone else who is more akin to giving out personal recognizance bonds for people who assault their mother. But I am going to give him a bond of $1,000 cash surety with GPS tether, victim notification if possible. I'm going to reiterate again for Mr. Barton. You cannot have contact with Miss Fitzgerald, not directly, not indirectly. You can't go to her house. You can't go to her job. You can't go to her school. You can't go to the supermarket that she's at. You can't go to the laundromat that she's at. You can't go to the church that she's at. You can't have any conversation with her for any reason at all. Is there any point of those bond conditions that you are confused about at this point?
No, Your Honor.
Okay. Also, you need to appear for your court dates. You have an attorney that is representing you on this matter. Do you know your attorney's name?
No.
Mr. Annette, who's representing him?
If you give me one moment.
I have it's John.
Hello, yeah, what'd you say?
I have John Lee as the attorney, but I just want to confirm.
If it's Flores, that sounds about right.
Okay, you have an attorney. His name is John Lee. He's representing you on this matter. He's the person that you would talk to. The prosecutor would never talk to you on this matter because you're represented by an attorney. And it's unlikely that you spoke to a prosecutor about this because you never even showed to court. So you need to report to all of your court dates, and you need to be on time, and you need to not try to call your mom from jail because the prosecutor is going to listen to your jail calls. You understand that?
Yes, ma'am.
Any additional matters for the record?
Yeah, just for the record, what address did he provide to the court?
Oh, he previously provided a different address. Let's see what he said. 607 East Michigan Ave is where he said he was going to stay previously. Are you planning to stay at the 607 East Michigan Ave or another address?
That's the mission, yes.
So, Mr. Martin, is that where mail should be sent?
Yeah, either there or, yeah, probably just there.
607 Michigan Avenue.
I think so. It's the mission.
Okay. East Michigan.
That's correct.
Okay. 4910. Okay. I'm gonna let your attorney know that you're in custody, and we see if he can meet with you sooner than later.
Thank you.
Okay.
You're all set. Are we ready on Mr. Woody?
Yes, we just have to go grab the tablet and connect to your courtroom.
Are you ready for something?
Yeah.
I'm here to.
It's Daniel Sneed.
He's waiting for what?
He wants to request an extension on this.
Oh, he could have did that a long time ago. What does he need?
Should I come up?
She'll get it.
You can give her the information and she'll understand why I'm here.
Ron, you made him sit through all of that long arraignment for this?
It's okay, I'm patient. I'm patient.
Okay, let's see. You were supposed to make a payment for something?
On the 22nd of 75, but as you see, I gave you my information as to why I can't on the 22nd. I recently just moved up from Arizona, so.
Okay, you need how much time, sir?
This is a little more than the 22nd. You know,
Well, I need a date, that's all. Can you get the file for me?
I just got my unemployment today, so I have to pay pay them all of that, so I work for,
Need another 30 days?
please.
Okay,
please.
that's fine. She'll grab the file so I can note it, and then you can give him his paperwork back, and you're all set.
I appreciate it, thank you.
Does he want his ledger back?
Yeah. Did you want your ledger?
Yes, yes, yes.
There we go.
Hello?
You're,
Yeah. Hello?
1 second, sir.
Oh my God. Straight bullshit.
Can't see. Can I meet with Woody in a breakout room if I have a moment?
I can't hear nothing you're saying.
1 second, sir.
Right, I can hear you now.
1 second.
George, you have had a chance to speak with him at all?
No, they didn't, and I wasn't able to this morning. He was refusing.
Okay.
If I get like 2-3 minutes, I'll give it a shot.
Bye. No fucking attorney, no nothing. Fuck him.
My understanding, you did not get to meet with him?
Yeah, he refused to appear this morning.
Oh, okay, well then he's not being arraigned today. He'll be arraigned tomorrow.
All right, bye.
You're all set.
Is that it for today, Judge?